So you've been involved in an auto accident in Columbus, Ohio, and you're wondering what your next steps are. So being involved in an accident is a complicated situation. So you've gone to the ER or you're feeling pain the next day and you're wondering what you should do. Well, first, you need to make sure that you're receiving adequate medical treatment. That's the first step. As long as you're receiving adequate medical treatment, you're going to get better. And if you've been to the ER and they've told you what's going on, then you want to make sure you follow up with your primary care physician. But you may be wondering what's going on the legal side. So you've got two insurance companies involved at least, if it's just a two-car accident. So you've got your auto insurance and the at-fault driver's auto insurance. Their auto insurance company is most likely going to try to give you a call within a couple of days to try to figure out what happened. Uh, it's our recommendation that you don't give them a recorded statement. Uh, your contract with your insurance company most likely requires you to do so for yours, but for the at-fault insurance company, you're not required. And so the question remains is, how is that other insurance company going to try to pin any of this fault on you? Or even say that the crash was such a low impact that you can't be injured. If you don't believe me when insurance companies will say that about certain types of accidents, I can show you all of the lawsuits we've ended up having to file because an insurance company's response to my client's treatment is, well, the accident was too low of an impact for them to even be injured. And so that response could be something that they give back to you. So the reason to have an attorney on a case like this is that the insurance company has an adjuster who's trained to settle your case for as little as possible and as quickly as possible. There's one insurance company specifically that will call you 2 days after your accident if it was reported to their insurance, and they'll say, we'll give you $1,000 and $7,500 for your treatment over the next 6 to 8 months. So there's a couple questions when people call me and they ask, is that a fair settlement? The first question is, do you know that your medical bills are only going to be 6 to 8 thousand? And usually the answer is no, I don't know that. The second is $1,000 going to compensate you for your pain and suffering? For the most part, the answer is no. But the other part that's in there that that an insurance company is not going to tell you about is the subrogation from your health insurance company. And so what is subrogation? Subrogation is just a really fancy legal word for, I want my money back. And your health insurance company, if they've paid any money out, wants their money back because there's an at-fault person. Now, if you get the flu or you go to the ER because you have stomach pain, unrelated to somebody else being at fault, like an auto accident, your health insurance company never comes to you and says, hey, injured person, I want my money back. But really, they want their money back from the at-fault. So when an insurance company offers you this $7,500, first, you don't know how much your medical bills are going to be. But second, if your health insurance pays any of that money, most likely that insurance company is not going to pay the subrogation cost to your health insurance company. So let's say your bills out of your own pocket are the full amount, $7,500. And then your health insurance company gives you a call and says, injured person, you were involved in an auto accident. Your health insurance contract requires that you protect our subrogation interest. We want the $1,000 that we've paid on top of all of the other bills that you had to pay out of your own pocket. So the $1,000 you just got for your pain and suffering now goes to pay your health insurance company, because if they don't, if it's a private insurance company, then you could potentially lose your coverage because it's in your contract. Now, how many people have ever read their health insurance contract? Very few. I know that I've read mine only because I know I want to make sure what's in there. But just like with your auto insurance, most of the time you're not going to sit down and read through sometimes 100 pages of what's going on in your insurance contract. So that's just the baseline. That's just the baseline of what's going on. That doesn't even include your auto insurance med pay. If your med pay pays any of that, then you've got another lien on your case that the $7,500 isn't going to cover. You got $5,000 in med pay. You've got health insurance. There's a bunch of different things that are going on that are going to go on throughout your entire case, and that doesn't even include if you have public assistance. So the one situation I'll tell you about is I had a client who was involved in an auto accident before I got involved. And she had settled that other case, and then I got involved in the second accident that she was involved in. When I contacted Medicaid, they alerted me to the fact that there was money that she still owed on this other case through ODM's, Ohio Department of Medicaid, subrogation interest. So you may be wondering, well, what happens in that situation? The Ohio Department of Medicaid will put you in collections over a subrogation amount that you didn't pay back. And the auto insurance company that you settled with does not care. They don't. So if you get a settlement offer and you accept that settlement offer from the insurance company, they do not care that you have a Ohio Department of Medicaid lien. And your hope is that you got more money than the Ohio Department of Medicaid lien. Now there's an Ohio formula that they have to go through. If you only recovered $1,000 and your bill's $1,000, there's a certain amount that gets reduced for that. But still, you had $1,000 Medicaid lien and you settled for $1,000. My point being with all of this information is not to overwhelm you, but to help you understand that there is a lot of stuff going on here in your personal injury case that your goal is to get treated. And your goal when you hire somebody like me is to start handling a lot of those other aspects and make sure that when you walk out of my office on the last day, there is nothing more for you to deal with. And so if you're looking for an attorney here in Columbus, Ohio for your auto accident, give Bressman Law a call at 614-538-1116, or you can always email me at jedediah@bressmanlaw.com.